Ladies and gentlemen of the Senate, yesterday we got to see our new Attorney General, Jason Miyares, in the balcony, and it was nice to see him. The Attorney General graduated. He's a fellow Duke, graduated from JMU about 5 years ahead of me. He's our first Duke in public office. First Duke in statewide public office. It was good to see somebody from the JMU caucus elevated statewide. And however, I just want to say that there's been some things that have happened in that office since he took over, and also before he took over, that I think raised some concern. And I just wanted to bring that to the attention of the body. As you might know from the paper, the day before, I believe it was the day before the inauguration, about 30 people were terminated from the Attorney General's staff. There were 17 lawyers and about 13 staff. Apparently, the Attorney General's office doesn't have the same civil service protections that other agencies of our government has, and attorneys know that they're subject to termination from time to time. I wasn't aware, though, that the Attorney General's staff, even career people, non-political people, were capable of being terminated. But I can just tell you, Madam President, I had several concerns about exactly how this was handled. First of all, amongst the 30 people that got terminated, most of them received about 26 hours notice that they had to turn in their ID cards, their staff, their laptops, and empty their office. There were several of them that actually got less notice than that because HR apparently forgot to send the email, so they got somewhat less than that. They ended up going to HR and ask a question and found out that HR forgot to send them an email. But in any event, that's really a disappointing way to me to handle civil servants, especially career civil servants. Some of them were basically told they had till Saturday to get out. Once that happened, they were locked out of the building, locked out of the parking garage, locked out of their office, and most of them were terminated without even being told what their benefits were. Most of these people have families. Some of them have medical conditions. They didn't know whether or not they had continuing benefits, whether they had COBRA status. They didn't know, exactly what termination meant. The normal things you would normally associate with a termination, they were never really advised of. It was kind of an unusual way, I think, to handle termination of government employees, especially non-political ones. Secondly, Madam President, what concerns me is that I'm not sure a lot of the terminations really reflect an understanding of the legal responsibilities of the Attorney General's office. And when I say that, we all know that the Attorney General has some discretion about how to structure their office, and they can put labels on things, but the entire Civil Rights Division got fired. And you might say that's a policy decision. However, I just want to note the Civil Rights Division, or the lawyers within it who were terminated, we're working on 9 cases that Virginia law says the Attorney General is required to file. They don't have discretion about whether to file the case. When certain boards in Virginia, for example, the Real Estate Board, the Fair Housing Board, when they make a finding that discrimination has occurred, our Attorney General is required to file a lawsuit. It's not a policy decision. They have to file it. And those cases are filed and pending. Madam President, one of these trials has a damages hearing in February. Another one has a full trial set in March. There's other cases that are currently pending in discovery and in settlement discussions. There's another trial set in August. There's another one set next year. There's also 11 other cases where the Attorney General's office is currently one of the fired lawyers is sitting as second chair. Many of them involve new statutes that we passed, that we charged the Attorney General with enforcing. For example, we passed a statute last year, you all might remember, that prohibits landlords from discriminating against tenants based on the source of funds, so that you can't tell somebody you're not going to rent a property to them if they use a Section 8 voucher. Apparently, many of our landlords in Virginia haven't figured out that's now against the law. The Attorney General is currently trying to enforce that, but the lawyers that are enforcing those lawsuits all just got fired on 24 hours' notice. Madam President, there's also cases which I talked about in the Richmond Times-Dispatch involving several larger landlords in the city of Richmond. And also, some lawyers in the Civil Rights Division got fired. Many of them they've already have pending investigations, pending cases, some of which have been filed in court involving the Virginia Values Act, some of the civil rights statutes that we've passed. You may have seen that in the city of Virginia Beach Police Department was recently discovered to be using false documents to get people to confess, which is probably not only a violation of civil rights statutes, I think it actually constitutes criminal conduct myself. Forging public documents, if any other human being was to do it, you'd probably pick up a forgery felony charge. But apparently that it hasn't, the Virginia Beach Commonwealth Attorney hasn't seen fit to do that yet. But in any event, some of these are very serious violations that we're currently in process. I would also just note that pretty much, I think, everybody in the Conviction Integrity Unit got terminated. And I would note that the Conviction Integrity Unit, again, you can put whatever label on it. You don't have to have a Conviction Integrity Unit. You can just tell people in your office that's what they're going to do. But these people fulfill our government's constitutional responsibilities. And I'm not talking about the Constitution of Virginia. I'm talking about the United States Constitution. When the government learns that people were wrongfully convicted or people were convicted using false testimony, there are certain responsibilities that arise to remedy that. And that's what the Conviction Integrity Unit was working on. They were investigating. There were 4 people in that unit. All 4 of them got fired. They were investigating claims of wrongful conviction. They were responding to petitions of writ of actual innocence. They were working on Innocence Project cases from around the state. And the way it works is when somebody says they're wrongfully convicted, somebody has to do an investigation to confirm or to find out whether those allegations are true. And these people were doing that to fulfill, again, the Attorney General's United States constitutional responsibility to properly investigate claims. And now apparently those 4 lawyers doing it were terminated. Now obviously they could be replaced. All these people could be replaced. But Mr. President, Madam President, I would note that this raises a third issue. And that is the Virginia Code of Professional Responsibility. Now I know only a few of us here are lawyers, but as an attorney, as a licensed Virginia lawyer, you as an attorney have an ethical responsibility to your client. And the client in this case is the Commonwealth of Virginia. It's not the Attorney General. It's not Mark Herring. The people working in that office have an ethical obligation to their client, the people of Virginia. And the Virginia Code of Professional Responsibility has a specific rule when it comes to declining or terminating representation. Just so you all understand, when you as a lawyer, when you enter an appearance in the case and you say, I'm the attorney for so-and-so, you don't just get to walk out of the case, say, I'm not doing it anymore. That's not how it works. You have to file a motion to withdraw. You have to appear in front of a judge. You have to tell a judge, I'm leaving this case. You have to give a reason. The judge has to look at the situation and decide it's appropriate. And then the judge has to grant you permission to get out of the case. And then you're no longer obligated to respond to pleadings, to appear in court, to do those things. And the client has a full right to fire a lawyer, but the judge has to approve it. Until the judge approves it, until the judge says you're out, you're in. 17 lawyers in that office were in a case. You can't get out of a case in 24 hours. That isn't how it works. And the Virginia Code of Professional Responsibility says, as an attorney, you're only allowed to get out of a case by using steps reasonably practical to protect a client's interest. And the rules go on in the commentary to say that even if the lawyer has been unfairly discharged by the client, the lawyer must take all reasonable steps to mitigate the consequences to the client. So in other words, as an attorney, they have an ethical obligation to make sure the people of Virginia's interests are not prejudiced by the way they've been fired. These lawyers don't know whether they should be filing motions to withdraw in court. Right now, they're on the hook for anything in that case. They were unable to transition the representation. So, for example, if you get fired as a lawyer in a case, what you typically do is say, okay, client, I'm getting fired. That's great. You call the new lawyer and you say, here's what's going on. Here's the pending case. Here's what's going on in the case. Here's where discovery is. Here's what's going on with the witnesses. Perhaps you prepare them a memo so that the client's interest is not prejudiced. Nobody was able to do this because they didn't have time given the way they were fired. Okay? And so now you have a bunch of lawyers questioning whether or not they're all going to be facing bar complaints because of how they were terminated from representation and basically ordered they're not allowed to do their job. And Madam President, I would just note that this just isn't how you do a transition. It's not. When lawyers move on or whatever, there's steps you have to take. I had to terminate working together with another lawyer once. There's certain ways you have to do it. You have to notify the clients and put them on notice, and it takes time. It usually takes a couple weeks. This isn't how you do it. If you're a doctor, say you're delivering a baby, you don't just walk out of the delivery room in the middle of the delivery because the client says, I don't like the way you're handling this, you're fired. You got to see the project through. If you're going into surgery, you don't just bug out right before the surgery and just see whoever shows up to finish it. You have a responsibility to that person to see the job through and to do it correctly and to withdraw in a way that can be done properly. So, Madam President, I appreciate the Attorney General. He can make lots of policy choices. He can change the way he runs that office. He can restructure it. He can put whatever labels he wants on the different offices. But you can't fire 30 people in 24 hours that are involved in legal matters. That ain't how it works. And it gives me serious concern about how seriously that office takes its constitutional and its statutory responsibilities to represent the people of Virginia on the matters that we have tasked them as this legislature as things they have to focus on. And I really hope going forward they figure out a way to clean up the mess they've created and that they take the responsibilities we've given them very seriously. And I would hope, and we're going to be paying attention as this continues to go forward to make sure that the transition is done, hopefully, better. Thank you, Madam President.